Hi, everyone. I'm Nancy Wilansky. I'm the director of the Alliance for Nonprofit Impact. Thank you for joining us. I know we had some additional people register, so they'll be popping in or listening to the recording. So thank you for making time for this. Thank you to John for being willing to share his expertise. John has a background in working in nonprofits as well, so he understands the challenges that you all are facing, but now is in a leadership role at the Department of Labor and Training. And so he is going to give us an overview of some of the important laws that you need to be aware of regarding employment in Rhode Island. So thanks so much, John.
Thank you. Appreciate that. Yeah, so I usually don't do a deck for the employment law basics chat because I find there's a lot to get through and the deck tends to bog us down. I've learned over the years that pretty much all of my presentations are somewhat boring, and my wife says that's because I'm boring, which I'm still trying to figure out a good comeback for. So if anyone has a response, I'll steal it. But employment law basics, unfortunately for you all, is in some ways the most boring because there is so much to cover and because we're going to look at it from a pretty high level. That said, I will try to get through the talking part as fast as possible, if only because my lack of deck means I'm just staring straight at my own face, which is torture. Um, and so there'll be 10 topics that I'll work through. I will get through them as quickly as possible. If anyone wants to jump back to any of the 10 topics, I'm happy to list them again at the end if you need to be reminded of which one you wanted to dive in deeper on. Or else after my presentation, I'm also happy to just take specific questions. I know that these sessions are often most useful for sharing fact patterns that you all are experiencing. Feel free to remove any identifying information from those fact patterns, and then we can analyze them together. And usually those lessons are applicable for most folks on the call. So that's what I try to get to as quickly as possible. But let me give you these basics. Well, a lot of it you'll probably be familiar with. Some I'm just gonna either remind you of or perhaps tell you about for the first time, and happy to go into further detail here today, or else I will include my email in the chat before we finish, and folks should just reach out to me anytime, like truly anytime. And you can share my email with anyone you like, except, if you really focus on the people you like part, because if they're terrible, don't share my email with them. All right, let's start with minimum wage. So right now, our minimum wage for the state is $16 per hour. In 2027, on January 1st, it'll go up to $17 an hour. And currently, there are no further out year increases planned. Usually, over the last decade, the General Assembly has been going up $1 a year, but usually they'll set it for 3, 4, 5 years of increases. Last year they only did the two, and my guess is they're not going to pass anything this year. They'll let it go up to 17 for next year and then see what economic and other realities of our state are at that point. Relevant to nonprofits, there isn't really like a training wage or a starting wage in Rhode Island. There's one very narrow carve out now, which is for full-time students. In theory, they can be paid at 90% of minimum wage, which right now would be $14.40 per hour. I've often, in my own experience in talking to folks, have found that the administrative headache of that slight shift in compensation can be not entirely worth it. But that is the one exception to the general minimum wage in our state. I'm not going to get into tipped minimum wage because usually not super relevant for nonprofits, but if anyone wants to talk about it, just let me know. All right. Let's get into overtime and premium pay generally. So Rhode Island has uh two premium pay schemes. One is the same as the federal system, the overtime premium pay that we're all fairly familiar with, time and a half for non-exempt employees. And I'll get into the details on exemptions in a second. But we also have a second premium pay system, which is unique in the nation. It is our time and a half premium pay for folks performing work on Sunday or certain enumerated holidays, the big ones for the most part. Um, Work on those days is considered voluntary. A person cannot suffer, an employee cannot be subject to adverse consequences for declining to work on a Sunday or enumerated holiday. And for the most part, the time and a half premium pay kicks in. Rhode Island, the department has taken the position, courts haven't really settled this issue, but our interpretation is if someone is eligible for overtime because for premium pay due to overtime, meaning essentially more than 40 hours of work or more than 35, depending on how you frame your scheduling. Once they exceed that threshold, they would be eligible for time and a half for every hour worked over that threshold. If someone works 45 hours, they're eligible for time and a half for those 5 hours, assuming they're not exempt. And then if they also go on to work on a Sunday, maybe those 5 hours were on a Sunday, it's our interpretation that you'd have to stack both premium pays. So we try to avoid folks saying, all right, you're going to be my Sunday premium pay, you're going to be my 45-hour premium pay, because we want everybody to be paid fairly and for the work that they are doing. Um, so that's premium pay and overtime. The state recently in 2023 passed or enacted a pay equity law that is quite robust and I think moves the conversation in a positive direction. The fundamentals are, well, actually, you know what? Let me step back 1 second and talk about exemptions for overtime for a second before I get into those. So there are, for the overtime exemption, there's what we typically call the white collar exemptions. So we're talking about a combination of high wages and uh, bona fide, genuine executive functions. So supervision of employees, of other employees, hiring and firing power, the ability to set budgets, the ability to independently run a branch of the organization. Those are the kinds of bona fide executive functions that we look at when assessing whether someone is exempt from overtime premium pay. The salary is set federally right now. Rhode Island has a de minimis threshold that's decades and decades old that has no relevance anymore because it's now below the state's minimum wage. So we just ignore it and go with the federal um, salary criterion, which is a salary of $684 per week. So if someone's making less than that, they are going to fail the exemption test, even if they have significant executive oversight um, functions within the organization. And so those are really the pieces you want to walk together. Is the person making enough money to potentially be exempt? And then are they genuinely in a position that is truly one of autonomy, authority, or other executive function?
Just want to
Uh,
jump in here. So for folks who are, I think we have some very experienced folks on the call and some less experienced folks on the call. So you're talking about the distinction between hourly or salaried employees, sometimes called hourly or salaried employees, which corresponds to the exempt or non-exempt. And the what would be the implications of misclassifying someone in one as one or the other?
um, there's a variety of enforcement outcomes. From our perspective, the most important thing we want is to see the worker made whole. So we would start by saying, we try to come in with an education perspective. The only time you'll see us coming in from a posture of, serious investigation and enforcement, aggressive enforcement, is if we are encountering intentional bad actions, folks who are intentionally underpaying their employees so that they can either reap more financial benefit for themselves or they can underbid competitors. Those are the scenarios where we'll step in with a heavy hand. Otherwise, our approach is to start with education, make sure that the employee gets compensated in full, but we try to keep away from stepping up into punitive outcomes for as long as we can, unless there's strong indicia of intentionality or, uh, sort of obvious neglect.
And so you said that 684 is the weekly threshold, correct? So
Yes.
that if you multiply that out by 52, that is 35,568. So basically
Yes.
what you're saying is that anyone, no matter what their job responsibilities are, who makes less than 35,000 um, needs to be considered an hourly employee eligible for overtime. Is that correct?
Yeah, yes, for conversational purposes, absolutely. I shy away from the distinction because there are unique or rare sets of circumstances where a person would be what we commonly recognize as a salaried employee, but they end up working so many hours that we actually have to treat them as an hourly employee and start to figure out what they're getting paid hourly because they might be getting less than minimum wage, or at some point, if they're working so many hours and we get into a situation where there's uncertainty on some of the executive authority function components, we're going to start scrutinizing. If someone has a salary of $36,000 a year, but they're regularly working 70 hours a week, we're going to start wondering whether that's illusory and intended to evade the overtime requirement.
But basically, if you have employees who are under that, the assumption would be that they are need to be considered hourly and be eligible for overtime. And so if
Yes.
anyone on the call has employees who make less than that threshold and they have questions, they can reach out to you. But in essence, that's something that no matter what responsibilities they have, um, even if they are supervising someone else, they would still fall into that category. I just wanted to expand on that just a little because I know that that tends to be a sticky and not always clear distinction. So sorry to
Yes.
interrupt. Just wanted
No,
to.
no, please, anytime. It's super helpful. The other, it is an increasingly difficult issue for nonprofits. That 35,568 was scheduled to go up under the Biden administration, but then there were court challenges, and the Trump administration is not particularly interested in raising that threshold. In the nonprofit context, it is complicated at times. It's not as clean cut. I would outside of the nonprofit context, I would say unequivocally, let's raise that threshold every opportunity we can. But I do recognize that within the nonprofit universe, funds can be hard to come by, and willingness to perform work might be there beyond what the organization's means to properly compensate actually is. And we'll get into that in a minute when we start talking about volunteers and interns. The other thing that I've seen folks trip up on occasionally, and again, this is one where we're going to come in with an education mindset. Sometimes you'll have a program director or an executive director who's making above the threshold, and the assumption is, well, they're the top boss. But if they have fewer than two employees, they might not actually pass the oversight authority test. So EDs with only one or two employees is where we want to sort of zoom in and do a one-on-one analysis so that you can be more confident in your assessment. And yes, we will go over independent contractor stuff more broadly in a couple topics. All right, so I'm going to try to move through pay equity fairly quickly. We can do a whole session on that another time, but essentially, one should think of it as equal pay for equal work with a few quirks. So technically, the law is focused on preventing protected classes of people from being paid less than non-protected classes. So usually we talk about someone that looks like me just getting an extra 10K a year because I look like me. And that's what we're trying to, as a state and as a country, that's where we're headed with this policy, is to try to get rid of that and make sure that people are compensated for bona fide work factors, the work they do, the type of work they do, and what they bring to the work. But, very concrete aspects of what they bring to the work, things like educational attainment or work experience, or in certain industries, objective evidence of superior performance often, but that's got to be something that is truly objective. We've got a sales, sales totals, those kinds of like level of specificity to really be able to differentiate two people in the same position based on skill or productivity. So I strongly recommend that folks review the nature of the work that their staff do. I think the best way to do this analysis is to basically just list all of your staff, list their functions, see if people have substantially similar, and then list their pay. And if someone has a substantially similar function to someone else and a pay disparity, that's when you need to look at whether there's one of those bona fide factors like experience or educational attainment, longevity that would justify that disparity. Um, a relatively new issue that Nancy and I spent a lot of time on, and thanks to Nancy, saved the day, is a new law that requires specific types of notice to be provided to new hires. It's fairly robust. We have a checklist on our website of everything that needs to be communicated to new hires. Um, Things like their rate of pay and the basis of that, whether they're hourly or salaried, whether there are any allowances for meals, or if they're getting a lodging voucher or something, housing voucher, something like that. Then they need to be informed about PTO, when they'll be paid, what's going to be in their pay stub, those kinds of things. Um, it's new. We're going very gently on enforcement. The penalties are not terribly harsh at this point. It's $400 per violation for the first and second violation. But again, we are very much in an education mindset right now. All right, let's touch on some of the social insurance programs that we run, TCI and TDI. TCI, temporary caregiver insurance, is the state's paid family leave program for the most part. It provides compensated, taxable leave, so that the benefit is unfortunately subject to income tax. Um, it provides up to 8 weeks of leave for either taking care of a family member um, who requires care because of a medical or other condition, or for bonding with a newborn, an adopted child, or a fostered child. Um, and it comes with job protection. An employer cannot take adverse action against someone for taking advantage of their right to access TCI. And as I said, it is taxable income, unlike our other program, temporary disability insurance, which is our program for when an individual themselves is unable to work due to illness, injury, or disability. The basic eligibility criteria are the condition will take you out of work for at least 1 week, and you have earned about $19,000 or so in the previous year, or 5 quarters, really. Um, and then the evidence piece, the component that needs to be provided to us, is a form that we send. When you file, you indicate the healthcare provider that you are working with. We'll send them a form that they fill out and lets us know the length of anticipated leave, and then we'll send a form to your most recent employer to find out final day of employment, and so we can address so that we can provide the leave the benefit as soon as possible once the leave starts. Um, I'll touch briefly on unemployment insurance, UI as we call it. It's, again, also a topic for an entire session another time. What's really relevant for nonprofits in the UI universe is, in Rhode Island, nonprofits are eligible to opt out of UI tax. So UI tax is calculated across two different axes. It's somewhat annoying to explain. There is a tax rate that is set based on how much money we have in our UI trust fund. That trust fund is filled with money paid by employers as a form of payroll tax. And when it is healthy, we can reduce the tax rate accordingly to take the burden down off employers. And if we are going through economic hard times and lots of people are on the program and the trust fund is expending dollars at a very high rate, we have to raise the tax rate to keep it solvent. And then there's a second component, which is based on an employer's interaction with the unemployment system. So an employer, a large for-profit employer who regularly lays off 300 people at a time, as a cost-cutting measure, is going to end up with a very high, what we call experience rate, meaning lots and lots of their former employees are interacting with the unemployment system. That means their personal tax rate will go up, even if the state's tax rate goes down, because they are engaging in behaviors that implicate the fund with great frequency. And so nonprofits can opt out of the system altogether and instead self-insure so that if a person does separate from employment with you under qualifying circumstances, meaning it was no fault of their own, either it's a layoff for lack of work or maybe a grant ended and wasn't renewed. If the nonprofit has elected to opt out of the tax system, we would still administer the claim. Everything's the same for the worker, but we would eventually send you a bill saying this is how much we paid the individual for their unemployment benefit. And as you opted out of the tax, you are considered a self-insurer. So you have to remit to us the amount that we paid to them. So that is the nonprofit carve out for the UI tax system. There are other employer taxes that have to be paid. There's, um, a slight assessment for what we call the Job Development Fund. It's what powers our workforce development training system to help folks advance in their careers or reattach to the workforce after a period of unemployment. And I think let's finish with independent contractors and volunteers and interns. So for an independent contractor, the test that we use to determine whether someone is genuinely an independent contractor coming along to do some form of work for an employer, or if they're an employee who's actually just their entire work relationship is one-to-one between them and the employing entity, and they don't actually have their own bona fide business of their own that is being brought on. So we look at a few different factors, things like who controls the person's schedule. When I was working at a nonprofit, we had a part-time accountant who came in when she wanted, and basically our agreement was you'll work X number of hours per month and perform basic accounting functions as you deem necessary for our organization. And the person would, they had a bunch of clients across various nonprofits, and they would come in on their own time whenever it fit their schedule, and they would perform their services for us and then go off to their next client. And that was, the easiest example in some ways of an independent contractor that, or, if you have an IT service that only comes in when you have a problem, as opposed to someone who's there all day in case anything comes up. Again, fairly basic independent contractor scenario. Where it starts to get less clear is if you have a line of business. So often we talk about this misclassification of employees comes up the most in construction. So we'll talk about a scenario where you have a general contractor building a house, and he's got a group of people that he uses for every house he builds. They use his equipment. They are summoned on the employer's time. And I'm using him because I'm actually thinking of a specific employer who we just dealt with, because he gave me a very clean example. And But he had established this drywall company and even set up an LLC for his three people that worked exclusively with him, installing drywall whenever he was building houses. They didn't do drywall anywhere else. They didn't hold themselves out as hireable for anyone else. But he tried to say, look, they're an independent contractor. They've got their own business. They just come in and do drywall. I don't do drywall. But on closer examination, it was very clear that that was all just pretext to try to avoid paying workers' compensation for them, to try to avoid paying UI tax for them, and to underpay them for the hours that they actually worked. So that's the sort of main distinction is really who's controlling the services being provided, whether the services are offered to other clients. And, fundamentally, the gut check is, does this person just perform work for me? Or are they genuinely their own thing? And I just bring them in when I need a very specific service from them. Volunteers and interns. So the general rule is you can't work for free, except in the nonprofit universe. I think the single most important thing to keep in mind, at least from what I've been seeing recently, is lots and lots of us who work or have worked in the nonprofit sector are really good-hearted, hardworking, generous people. And I encountered in my time several members of staff who would say things to me like, all right, well, I'll work 40 hours for my regular pay, and then I'll just volunteer for whatever else we need to get done. Really kind and really admirable. And I think our society, Rhode Island, has made the decision to protect people from themselves on that front. So the easiest rule to understand with volunteering is a person cannot volunteer to do their own job. So if their function is X and they say, you know what, I'm not even going to try for overtime, I'll just do extra hours without reporting it. We strongly advise that you not let them do that because if we find out, then there will have to be further consequences. Beyond that, what we really look at is for interns, we want to see that they are getting some genuine benefit from the experience if they're working unpaid. And sort of mere experience, mere line on a resume usually won't be enough. There either has to be, we'll want to see some kind of actual skill acquisition happening in the internship to justify the lack of pay. And then volunteers, it sort of runs the gamut depending on the nature of the nonprofit. But typically, if it's a person just coming in and they have control over their own time and they say, I want to provide assistance at your front desk, or I want to help with a collection drive or whatever, that's usually a bona fide volunteer and doesn't invoke employee status. So that's more or less my big topics, and happy to turn it over to questions either about any of those topics or specific fact patterns that any of you are encountering.
You can go ahead and I'm going to change so that we can see everyone. You can go ahead and unmute yourself, or you can put a question in the chat, whatever is easiest for you.
Question on, can you hear me?
Yes. Yeah, go ahead, Betty.
Yeah. I have a question on the independent contractor. So you talked about work versus volunteer. So what happened for an organization that has activities after hours that relate to the organization's mission, and you have staff continuing to work during those activities like fundraising or like recruitment and so forth?
That's generally going to be considered employment work that would require continued compensation. And if by after hours you mean they've already worked 8 hours and we're talking about going past 40 for the week, at that point, they would have to be paid time and a half for that time unless they fit into the salary plus executive exemption.
Okay. Thank you. And a follow-up question to that is comp time. Can you say something? Can you say more about comp time and the
Um,
implications on salaried staff?
comp time is, other than the state's paid sick and safe leave law, comp time is largely left in the hands of the employer. It can't be used to get around minimum wage or overtime. It's a benefit in addition to appropriate wage compensation. So it's not really anything that we set the rules on. We just would keep an eye out to make sure that, you know, will if you're talking about sort of genuine comp time in the sense of instead of us paying you for hours 41 through 45, we'll let you take 5 hours off paid at another time. We'd have to look at the very specifics of how that's being done. It could work, but generally, for an hourly employee who's not at that threshold, we'd still most likely be defaulting to having to pay them time and a half for any hours worked beyond their regular work week.
I have a question about so if we have an exempt salaried employee who, say, is like a program manager, and some of the programs happen in the evening, but they don't have to be there for it, so they're kind of on call. How would you handle those sort of like on call hours, given this person's exempt, and so the amount of hours is like fluctuates? I guess we're just trying to figure out because that has come up a lot, just as like, oh, is this a thing we need to compensate for or take into account in some way?
If they're genuinely exempt, then you don't have to worry about it at all. They can be on call, they can be on site, they can do whatever they want, and it doesn't invoke additional compensation. If they are not, if it's not abundantly clear that they are exempt, then we encourage folks to be cautious with on call. Um, Rhode Island has a law that says if you call someone in and then ultimately decide that you don't need them, you have to pay them for 3 hours just for the inconvenience of having called them in. Sometimes that will get referenced in cases related to on-call status, and depending on how restricted the individual is by being on call, it might be considered compensable time. This would probably be one where it's easier for you and me to just have a phone call offline if you want to tell me more specifics, and then I can give you my opinion on that. I saw a question in the chat about paying benefits or providing benefits to interns. Um, it's a good question and one that really only comes up in the context of nonprofits. Uh, if the person is working what is considered your full-time week, um, and they're being paid at least minimum wage, they would likely be eligible for, or likely be required to be offered healthcare, health insurance benefit. It will really depend on what the nature of your internship program looks like, and the nature of the compensation for that. And again, I'm happy to have the one-on-one conversation and give my opinion on the specifics. Um, what makes an intern an employee versus an independent contractor? That question really will turn on the stuff I was talking about in terms of how much control they have over their own schedule and whether they have, because, we've had interns who they can come and go as they please. That doesn't necessarily make them an independent contractor. It just means that they are not necessarily working full time, in which case they would not be eligible for the requirement that they be offered health insurance. Interns are tricky. I get nervous with interns, so I usually prefer to have a one-on-one conversation about it.
Are there any things people need to keep in mind if they have a time limited position? So they hire someone to work with them for 3 months or to work with on a specific project. So they are taking them on as an employee during that time, not as an independent contractor. but are there specific things that they would need to keep in mind for someone who signs a contract knowing that it's a time limited, whether because it's a grant or whatever? Are there things that they would need to keep in mind for that?
Typically, that person is going to be due their health insurance benefit for the pendency of their time working for you. Um, with an internship, we're really going to be very focused on that benefit to the intern component. So if you're bringing someone on because you have a grant that needs to be fulfilled or because you have a little bit of extra money lying around in a project that you want to get accomplished, we're generally going to view that as just a regular hire, but simply a regular hire with a presumed end date.
And so they wouldn't need to communicate with you at the end date because it was a contract. So they're not laying someone off. They're just fulfilling the time frame in their contract.
They should still apply for UI, in my opinion. It's one of the risks or one of the factors an employer has to weigh when bringing someone on for a short period of time is that if that person is brought on for full-time employment. But again, you can have an independent, you could hire, when you hire a lawyer for 3 months, that's an independent contractor. You don't need to worry about any of this for them. So it's really going to depend on, are you bringing them on and then they're just fully adrift back in the employment market and not offering their services to other folks in a genuine independent fashion. If you have a grant writer who works for 6 different nonprofits and you want their full time for 3 months, that doesn't make them your employee. But it does mean we should just be careful with the analysis.
But it is something to keep in mind for folks who may have grant funded positions that they bring on an employee for a year. They are going to be thinking about that unemployment compensation as an additional expense that needs to be accounted for afterwards.
Yeah. Best thing you can do is find them their next job while they're still finishing up with you. Then you don't have to worry about it.
Other questions?
I have a follow-up question on the intern and time limit employment. So what do you do in the case of an intern who receive a grant from, for example, a foundation? And the foundation say, if you can find a nonprofit organization to intern with, we will pay your salary, and so forth. So in that case, this person is full-time. That person is time limit, for example, 3 months. So what is the nonprofit's responsibility when it comes to what you just mentioned about unemployment, health insurance, and the rest of it?
Typically, that's going to fall with the funding entity. It'll depend on the nature of the arrangement. I've seen instances where a person is stipended from a foundation, but they're working for a nonprofit. They're getting genuine benefit to themselves, even on top of that stipend. At that point, there's really no additional obligation on the nonprofit. There are other ones where a foundation will pay a salary, but won't take on, or they'll give a donation directly to the nonprofit to pay the salary, so they don't take on the role of employer of record for the short-term employee. At that point, the nonprofit would likely be on the hook for health insurance during the pendency of the employment. Yeah, these are the rabbit holes that are hardest to talk about in general terms and are, I think, the thorniest issues for nonprofits in a lot of ways. It's also why we have very light touch enforcement with nonprofits, because these are complicated and it is very easy to make a genuine error as opposed to my friend with a drywall lie.
There's a question in the chat about whether there's mandatory paid family leave in the works in Rhode Island. Is this something that the department agencies are working towards?
There's a bill in to expand TCI to 12 weeks, which I think from our perspective is the bare minimum, and we'd like to see that bill pass if possible. There's a lot of antipathy from the for-profit sector and business lobbying groups But yes, we are always looking for ways to. We worked on a bill last year to expand the amount of money a person receives in benefits if they're on TCI or TDI. That goes into effect in 2027. But yeah, we as an agency and this administration are pushing towards more progressive leave programs, more, our ambit is to increase individual and family per capita income and general wealth, and that includes benefit programs like paid leave.
I realize that you didn't touch on this, but can you just talk about terminations? So you have someone who is not, it's either actively harming or doing things that are not accomplishing what they need to be in the position. What are your rights and responsibilities as an employer for someone that it's not a layoff, it's not for financial reasons, but there's something about their performance that is impacted?
Rhode Island is an at-will employment state, like about 32 or 34 of the states in the country, which means you can fire or you can end the employment relationship with someone for any non-discriminatory reason. Um, there are where employers, I think, find themselves in an unfortunate position is mere bad performance does not necessarily disqualify someone from collecting unemployment after that separation. What I recommend for employers is have a policy handbook, share it with everyone that works for you, and apply those policies equally. Then you can build in performance policies that if an employee is genuinely unwilling, unable gets a little complicated, but if they're genuinely unwilling to improve following the performance improvement policy that you have written out and explained to them and applied evenly, then that separation will likely not make them eligible for unemployment insurance. I don't like to bar people from UI, but mindful of the cost to a nonprofit employer, if there's a genuine reason this person is causing their own unemployment because of their behavior, then they probably aren't eligible for collecting UI. It just needs to be carefully documented. And, what we see all the time is a rude employee who's just really unpleasant. And then all of a sudden there's a big blow up between them and the boss just says, "You're awful to everybody. You're fired. Don't come back." If there isn't a policy on the books about expected behavior and that policy isn't applied uniformly and explained to everybody uniformly, even that very unkind, terrible person who's making everybody miserable might still be eligible for UI if you just summarily fire them for being a jerk.
You just alluded to employee handbooks and policies. We do have a session coming up on May 21st. That's next Thursday, with the Employers Association of the Northeast on employee handbooks. So it's a multi-hour workshop. So if you have questions about what needs to be in your employee handbook or kind of assembling that, that would be a great thing to put on your calendar as well. We have time for a couple more questions if people have them. Lucy?
Hey everyone. My question relates to if you have employees that live in another state, and like this is new for us to have employees living out of state. So I just want to make sure we're in compliance, right? And we're doing what we need to do to make sure that we're not like violating any employment laws in other states. Like right now, we're just following Rhode Island's because the organization is based in Rhode Island. They were living in Rhode Island when they started working with us, but now they don't live in Rhode Island. And they moved to a state that has stronger employee protections. So they're in California. And so I'm just a little concerned. We have reached out to an attorney just to make sure we're doing okay, but I don't know if there's any advice that you can give us about what to be looking for, what to just make sure that we're protecting the organization and the employee.
I was going to say, I challenge that state to prove that they're more protected than we are, but then you say California, so they win. Um, do try to keep talking to that lawyer, try to get a final answer from them in the most concrete form you can. I would say as a general rule, barring California having a state law that hasn't been tested in federal court that is complicated and somehow tries to um, confer California benefits to someone working exclusively in Rhode Island, barring that unlikely scenario, you should just treat them like a Rhode Island worker. The employment relationship is driven by the laws in which the work is performed, even if it's remote. I mean, this got a lot more complicated after the pandemic, but generally speaking, even if they're sitting in California on a laptop, if they're performing work in furtherance of your mission, treat them as a Rhode Island employee.
Thank you. That's super helpful.
Where actually you do see people getting tripped up is if you have a multi-state employer. Yeah, we can get into it, but generally, for the employer's perspective, and frankly, this is largely fair to the employee, I believe. It runs with the state of employment's laws.
I have another independent contractor like classification question. So if I'm like hiring a camp counselor who has to be there for certain hours of the day, does that then sort of push into the like behavioral control aspect of like classifying an independent contractor versus a employee or yeah.
Maybe it would depend. Like if you know, let's say there's an incredibly skilled archery instructor in Rhode Island, and that person hops around from camp to camp doing 4 hours at this camp, 4 hours at that camp, and then the next day, a third camp, almost certainly an independent contractor. Camp counselors also have their own sets of rules that uh, are often just do away with these issues altogether. So again, that's probably one where it's best for a one-on-one consult whenever you have time. And I did put my email in the chat just now.
Other questions?
Just email me anytime. I'm around.
Anyone else? This has been incredibly helpful. Thank you, John. So we will send John's contact information in the follow-up email. We'll also include the link to the checklist document that John had mentioned. I did put it in the chat. We do also have it on our website in our resource library under operations, but we will send it as an attachment to the follow-up email. But like I said, and we'll also include information on the upcoming session on the employee handbook. We also have a session with EANE coming up next month on, for the title of it, HR Compliance 101. So they bring up additional issues, but that we will also send you information about that. John is amazing, and for sharing and being willing to meet one-on-one. We also, Alliance members, have access to the Employers Association of New England Employment Helpline. So if you would just have a question about general HR issues, they do have an attorney on staff, so they can also answer some employment law issues. That is available 5 days a week. And it's for free. So you can just call up and say that I'm a member of the Alliance for Nonprofit Impact in Rhode Island. And then you can just give them your question and have someone just on call as well. So that is also a resource, but I would also take advantage of a consultation with John that would be going right to the source. But just so you know, in an ongoing way, you have access to the employment helpline as well. And we'll include the phone number for that in the follow-up email as well. So thank you so much. And thank you, John, especially for making the time and for joining us. We will have John back to do some more content. He mentioned about 3 other different topics that came up today that might be full sessions. So let us know if there's a particular topic that would be really helpful for you, and we're happy to offer it. Thanks so much.